friends, welcome to Law Lectures. We are going to see the topic Writ of Habeas Corpus. Now we are going to see history of Habeas Corpus. Habeas Corpus was introduced by Britishers. Habeas Corpus is derived from the Latin word you should have the body. The Habeas Corpus was introduced in the Charter of 1774. Habeas corpus was introduced in Calcutta by English Colonies. The power was not granted to all the courts, only specific court as such Supreme Court of India have the power to hear the writ of habeas corpus. Before they have filed the writ only to the specific judge and Supreme Court of India. After 1774, the writ was sent from Supreme Court to even Municipal Court down. This wide expansion of this court is authorized lead to the conflict between the government and the court. It was decided that the court could explain its power to Munsif. However, the right was limited to the subject of British origin. After 1862, high courts were ordered to be established in three presidential towns where Madras, Bombay and Calcutta is inherited the power to issue writ of habeas corpus, and it is initially incorporated in the Code of Civil Criminal Procedure 1872. Meaning of habeas corpus: when an authorized person is unlawfully detained another person, we can file writ of habeas corpus. Writ of habeas corpus is a legal instrument that empowers people to seek relief from unlawful detention by compelling the detaining authority to produce detained person before a court or a judge. Once the fundamental rights is violated, the person can approach Supreme Court and the High Court directly in Article 32 and 226 of the Constitution. So you can file directly to the Supreme Court and the High Court. Features of habeas corpus. Habeas corpus is also known as writ of inquiry. Once your fundamental rights is violated, you can directly approach to the High Court or a Supreme Court. If there is insufficient ground to arrest, then the court will order to release the individual. It is an instrument to safeguard the individuals of an unauthorized detention by the person. Who can apply and what is the grounds? Let's see. First, friend or relative that the court may officially permit them to file habeas corpus. To beginning the writ process can submit and publish a petition for a habeas corpus against government body or a specific individual. The person who is being detained without any warrant typically requested a writ of habeas corpus. Writ of habeas corpus has been refused. In what are the grounds? Let's see. The court does not have the territorial jurisdiction over the detention of a person is connected with order of the court, or the person is detained is already set free. The confinement can be legitimated by the removal of the defects. The writ of habeas corpus will not available during an emergency. According to the 44th Amendment, we cannot proceed during emergency. Habeas corpus have two points of view. One is statutory power and another is non-statutory power. Let's see first statutory power. Statutory power. The person will be detained by legal authority. Example, a policeman. An authorized person, that is, a policeman can unauthorizedly detain another person is known as statutory person. Let's see non-statutory person. Non-statutory person, the person will be detained by the individuals. This non-authorized person, non-statutory person also we have got. So non-authorized, non-statutory person is a non-authorized person. That means an individual person is detaining by another person. It comes under non-statutory person. These are the case laws. Thank you for watching and don't forget to subscribe. Thank you.